Good afternoon and a very warm welcome to all of you joining us today. I'm Malikarya, Associate Manager Social Media at India IT 360, and it's a pleasure to host this Techie Connect session titled Navigating DPDP and AI Compliance 2026 and Beyond. Data is the new currency and compliance is the new competitive advantage. With the new DPDP Act coming into force and AI becoming core to every digital product, understanding privacy, governance, and responsibility is no longer optional. It's essential. Today's session is about clarity, what DPDP really means, how AI changes compliance, and how you can stay future ready in a regulated digital world. Before we move ahead, for those who are new to our community, here's a quick introduction. India IT 360 is India's first powerful B2B digital platform that connects technology leaders, professionals, and learners to share insights, industry perspectives, and real world knowledge. Techie Connect is an initiative by India IT 360, which is designed to bring tech students, professionals, industry leaders, and IT CXOs onto one common platform through webinars, expert sessions, and discussions. Techie Connect enables meaningful learning collaboration and career growth within the tech ecosystem. Now that you have a quick understanding of who we are, let me share what's in it for you. So now, let me tell you how Techie Connect sets you apart. So it provides you learning and career opportunities through our webinar series. And this session today is also a part of the Techie Connect webinar series, and it is curated especially for professionals, IT CXOs, and the tech students who are serious about building a future in technology and learning more about the new DPDP Act. So, when you register for the full webinar series, you don't just attend sessions. You unlock opportunities such as a chance to intern or work with India IT 360 and Unistal Systems. This is basically for the students, the tech students, a certificate of appreciation and an opportunity to get spotlighted within our growing community of IT CXOs and senior tech experts from leading Indian communities. So I'm dropping a link of the webinar series registration link in the chat. Do take a moment to check it out. And after the session, if you'd like to continue learning and growing more, you can join Techie Connect. Give me a second. You will just see the link right now. I've shared it on the chat. Now, with that in mind, let's now shift our focus to today's session. To guide us through our important conversation today, we are privileged to have with us Ms. Khushbu Jain, advocate at the Supreme Court of India. Ms. Khushbu Jain is a seasoned professional in data protection, privacy, and regulatory compliance with hands on experience in helping organizations navigate evolving data laws and responsible AI practices. It's an honor to have you with us today, Ms. Khushbu. The floor is all yours.
Thank you so much, Malika, for the introduction, and thank you so much 360 for hosting this session. All right, to start with, I think the basic and the first foremost question that comes when you talk about DPDP is why are we talking about DPDP and what is the need and why this act has come into existence, and why this need was created. So, and this question is rightly so, because if you'll see, every law that is created for a reason. It has come into an existence for a reason. Either there was a need of the society, or either it has created that the situation has come up, or for maintenance of decorum, or for a better running of a society. If you see through any law that has come into existence since its inception, there is a reason behind that. It can be for better governance, or the need or the requirement of maintaining of law and order, or something. The same thing has happened. See, we got IT Act in the year 2000. After 2000, the IT Act actually spoke about basics of giving recognition to emails, digital signatures, and wanting to incorporate technology as part of day-to-day life. And with that, it had some elements of punishment into it, very basics as to when it comes to hacking or taking an access, or so on and so forth. But that was year 2000. And with the year 2000, we are standing in 2026 today. With that, with so much has changed in the last 25 years, and it's not just 25 years, so much has changed with every 5 to 6 years, that the same IT Act also went through a lot of changes. But very soon, the same internet where we started putting across everything, we have a fear of missing out, that if we don't put anything on internet, something might go wrong, or we want to be visible there. Not having a Facebook or Instagram or a LinkedIn profile is also been looked down upon. Not having a physical address today as your office is okay, but not having a website or a digital presence will create that, oh, there is a fishiness, this might not be true. With that came the aspect that criminals also realized that this is a very good space, and let's make use of it. And not just criminals, others also realize, and we realize with time that data is playing a very important role. With technology surrounding us, be it internet or be it any of the IoT devices near you or whatever, they all are running on data. And this data is got a lot of potentials. When I say potential, it can be in a good way and it can be in a bad way. Good way, yes. More the data, easier for for people to create policies, for people to sell their products, for people to orchestrate or create a service oriented. What is the need? What is the requirement? I will put it across, and also better for you and me that we get better services. We don't have to look upon, and it so on and so forth. With that also came the aspect that if I get an access to data running a business and you don't get an access to data, that's an unfair play. Number one. Number two, when it comes to countries level, it was being said that a country's economy can run on if the company is the country's data rich and it knows how to process and utilize that data. With that, we came okay. But then data again, national data becomes a problem if it goes to the in the hands of people who it should not go. So one is benefit when it comes to business, second when it comes to benefit when it comes to nation, or also when it comes to security of the nation. The data plays a very crucial role. And third that comes is you and me, that my data, if it goes, one, it comes as a dignity. Second, it can have repercussions. I don't want certain things. I don't want to share my data with people. And number three, in that same element, in number three element, the second part is data plays a very important role in terms of any orchestration of a cyber crime. More the data with the criminal, easy for him to make you fall prey for his crime. And how so? We have seen, despite so much of awareness of the kind of crimes that are happening on the world of internet, still people are falling prey for it. How? Because these criminals have got a lot of data about you. Like for example, if I'll give you a call today, and if I say I've got um, okay, I have got, let's start with the first name. So I've got Advocate Kuljit over here, and I've got Amit Bajpai. Now, let's say with all of you, both of you, if I give you a call today and I say that I'm calling from XYZ Bank and there is a specific offer for you, if that bank is not yours and you don't have a bank account in that, bank, will you continue talking to me? You will hang up, right? Number second, let's say if I know that this is your bank account and I know which branch of yours, so I will say that I am calling from this branch of yours, from this bank. Will you have 1% trust? Yes, you will have an increased trust. If I then tell you these are the last four-digit phone credit card bank account number, and your last three credit card bill is ABC, will you believe that it is your bank manager? Yes, the level of trust will increase. Then let's say I increase a little more and I say that because of this credit card bill and because of your history of purchases and everything, we are giving you an offer, let's say, of shopping, and we are giving you an offer, let's say, of travel. Let's say you don't travel, so you will not be attracted. But I have a knowledge as a criminal that you travel, you do this. This is your bank account number. This is your last three credit card bill. This is your branch, and this is your travel history, or this is your spending history. So easy for me to make you believe in me that I'm calling from bank despite me not calling from the bank or sitting over there. So more the data, easier for them to make you trust them. Or trust can be for the aspect of luring you, or it can be for creating a fear. But the moment you trust, then any of these things work. Digital arrest, this is only what is happening in digital arrest. People, Pradhan Mantri has spoken on its Man Ki Baat that digital arrest and don't do it. And I was also very shocked when I used to get a call from the clients that digital arrest happened. And, I was there for 12 hours, 3 hours, 3 days, 30 days, 90 days, stuck in front of a screen and not been able to do anything, even when going anywhere. They're digitally arrested despite having no terminology as digital arrest, despite on the part that when we have our physical jails, practically we need people to secure that place. We need locks so that they don't escape. And here, practically, that other person is not even sitting in your vicinity, but just scaring you off. How? Because they have got data about you. With that data, that fear strikes in. The moment the fear strikes in, they play that psychological game and then they make you do things what you want to do. Once you enter into that, then you're stuck in between and you're stuck in between. Like, very small example I'll give you over here also that uh, bear with me. I know it's a DPDP class and I'm giving you a lecture on cyber crimes, but it's very important for you to understand so that it doesn't become a a thing which is a mandate that you have to comply with, rather than a mandate, that this is something which ideally, companies ought to do it. Okay. So the next point which I was telling you about, how they have a data, I'll give you some example that if I know this is you have sent an parcel to somebody, and then I tell you the parcel number and I tell you this is the parcel that you have sent on this date. Will you believe? Yes, you will believe. But let's say you have not sent any parcel and I tell you that something has been found which is suspicious on your parcel. You'll be like, I did not send any parcel, and you will not believe. Then I'll go a level next that there's an anti-money laundering case which has been filed. EOW has opened up a case and this has happened and this. And during the investigation, the money has been transferred from this to your account. There is an FIR copy and they send you an FIR copy. In that there is a bank account which is yours and there's a transaction details which is there and you're like what it is and how it is and you get scared and you're stuck. Or there are 20,000 more different variations which these criminals use as a story and keep putting you into it. All I'm trying to say is more the data, easier for these criminals. Apart from this, also the aspect that what I am today, I might not be able to relate with that 20 years later. Let's say at the age of 20, a professor has a picture, and 20 years later, at the age of 40, when he is a professor in an institute, he doesn't want to relate with that picture. That picture gets viral, and entire students are making fun of it. You want to keep that private, or you don't want to get related. You want that privacy over there. Now, in the digital world, this privacy was a difficult aspect, but in the physical world, we did realize that privacy and assets are something which are very clear demarcations. Like, for example, if I come to your house without your permission and chill there, it would be a trespassing. If I enter into your office and just enter, can I enter without your permission? No. Can I enter into your property and utilize it for my purpose? No. Can I come to your house, pick up your pen, pencil, and say that I'm in a need of it, let me take it? No. But in the world of internet, you are absolutely fine in doing all these things. Just because it is not visible, it is not seen, the boundary level, the aspect of taking the data is not visible, but aspect of taking a laptop of yours or a pencil or a pen of yours is visible. So this invisible part of it made it very this thing. And plus, we did not even realize that data could have that much of repercussions or that much of benefits. So Supreme Court in the year 2017, via K. Puttaswamy versus Union of India, said that we need to have something called as right to privacy in the digital space. Without this right to privacy, a person cannot live a dignified life. And right to life is your fundamental right. So there is an Article 21 in the Constitution, which is your right to life. That right to life is incomplete without having right to privacy as an embedded part of it. So from 2017, you got an additional fundamental right, which is your right to privacy. Now, when it's your fundamental right, nobody can take away without following due process and law and the exceptions which are part of it. Otherwise, no. But when I got a fundamental right as a privacy, can I say tomorrow that I want a bank account? I want to open a bank account in your bank, but I will not share my details because I have a privacy as my fundamental right. I want to be called as Lily, or I want to be called as Daffodil, or no name account. Or I want to travel via airline, but I will not share my details. Is that possible? No, right? But I've got right to privacy. So what do you mean by right to privacy? Let's say I want to call Uber, but I don't want to give an access to my location. I will tell him that come to this corner, come to here, and I'm standing here and you come there. But I will not share my location. Same, I will do it with Swiggy also. I will not share my location. I will not put my address also. When that guy will call me up, I will tell him one location and he has to come there, stand there, and come over. Is that possible? I don't want to go ahead with a KYC or details. Then what do you mean by privacy? Like, for example, if I'll enter into a hotel, I'll say switch off all the CCTV cameras because I have got right to privacy. I will not share my details. That's where the problem comes, that what do you mean by right to privacy? And what are your rights under that? Number one. Number two, what are the obligations of these companies? Can they give you a bank account with no name? Can an airline issue a ticket without issuing a name of yours? Can there be an aspect where I can check in a hotel without giving my details? Can I can I take an admission in a college without providing my basic details into it? Can that happen? If not, are they violating my fundamental right by invading into my privacy by asking me these questions? So, what are the obligations of these data fiduciaries? Why I'm using the word data fiduciary? Okay, Digital Personal Data Protection Act. Now coming on the part. So with that 2017 judgment, the court said that, okay, let's have a framework around this to understand the meaning of privacy and obligations under the privacy, which are there for the companies. With this, Justice Shri Krishna Committee was formulated. Justice Shri Krishna Committee went a step ahead and said that let me not just give you the framework, let me give you the bill itself. Now, that bill in 2018 or 19, roughly in between that, was being submitted in the parliament. Joint Parliamentary Committee was formulated, looked into it. Since that 2018-19 bill, it created an uproar in the world that India is coming up with its with its privacy law so stringent that there is something called as localization into it. There is something called as 7 years of imprisonment into it. The data cannot move out of India is a very serious issue, as because we were one of the largest, we are still one of the largest data generation country. We generate so much of data, which was very important. And 2018, we did not even realize AI so much, the Gen AI and the agentic AI so much, as we realize today that the importance of LLM and important of the entire data sets when it comes to training your models, AI models, how important it is. But countries in the West were companies in the West were very uncomfortable with that. So much of suggestions, so much of fights happening to and fro about it, that in the year 2023, by then there were 100 plus amendments that were there in the DPDP Act, in the bill, and the same bill was recalled in the parliament, and a new bill was presented, which was called as Digital Personal Data Protection Bill of 2023. This bill was being put across for suggestions. In the same year 2023, the act was passed, which is called as Digital Personal Data Protection Act of 2023, the DPDP Act of 2023, which is India's first privacy law. Now, we are also in that race of the countries which have their own privacy laws in place. Now, 2023, the act came. 2025, November 2025, that is a month and a half back, is where almost a month and a half back is where we got the rules, the 2025 rules in the DPDP Act. And that's where we're sitting. And that's where our discussion for the today's point is. Till now, I was just giving you the background that why data was important and what was the need of the law to come. Now that we have a DPDP Act, what does it say? It says, my data, my data, ask me the permission. Like somebody cannot come to my house without my permission. Somebody cannot pick up the stuff from my house and take it, however important for them, however not important for me, however number of copies I have of that item, they cannot take it without my consent. Same way in the world of internet, take my consent. Without my consent, you cannot take it. And tell me, what are you taking? for how long you're going to take it, which all parties you're going to share that data with, and what is the purpose of that data. You're taking it for advertisement, you're taking it for marketing, you're taking it for business development, you're taking it for KYC, you're taking it for providing a legitimate service to me. Like, for example, Uber need access to location at the time you're ordering a Uber. It's an important thing. You can absolutely deny location access when you're not ordering an Uber. Same way you can, if they're asking you the access to phone book or your gallery, you can absolutely deny it and you can share it. But this is up to you to share. The onus or the right is with you whether you want to give a consent for that or not. Now, consent also has an element. Consent is something, as I said, the things which they're asking you, if that thing is not directly linked with the services that you're seeking from them, you can deny those areas to give your consent. Rest other places where it is directly linked to the services, you cannot deny, or whether there is a legal requirement. Like, for example, for opening of a bank account, you have to provide KYC because it's a legal requirement. Now, my details are with them if I have opened a bank account with them. So I practically cannot deny them that permission. But if they have taken my other access, that comes to advertisement, that comes to others, that comes to marketing, that comes to research, I can always deny that. And I cannot deny it. So, consent. Now, they say that consent has to be very clear, concise, and you have to tell me what data, what purpose, which party, for what purpose, and how do I exercise my rights. All this has to be in 22 languages and English. 22 languages mentioned in the 8th schedule of your constitution. Now, it has nothing to do with that you are sitting in Gujarat, so you will provide it in Gujarati. But let's say you are in Gujarat as a company, but your user is in Maharashtra, is in Kerala. So the language should be in these two as well, because it is not where your office or registered office is, it is, or branch offices are, but because you're in a digital space, the user whose data you're taking, his language is the priority, and it should be provided in those 22 languages provided in the Constitution's 8th schedule. Now, with the consent, now second that comes is, I have given my consent, but I want to recall my consent. I have given it, but tomorrow I don't want to continue with it. Let's say today I want to, have I want marketing, I want advertisement, I want my other data also. But tomorrow I don't want to continue. So I can recall my consent. This is the second right in the law, in the DPDP Act. The third that is there is that right to access. Very important, right? That means I can now request any of these entities that, boss, I want to know, I want to access what data of mine are you using? And these companies are duty bound to provide you with details of what data are being utilized by them for what purpose. So your right to access. Then comes the next right to correction. That means I can request that I want to correct my data. Something is right, something is not right, something has to be corrected, and you can request for correction. And again, as I said, all these rights, the companies are duty bound. Companies, as in everybody who's taking your data, a data fiduciary is a duty bound. It can be a private partnership, it can be a proprietorship, it can be an LLP, it can be an HUF, it can be anybody. It can be a startup, it can be a company, it can be a large company. Anybody who is taking your digital data for the commercial aspect of it or whatever the aspect for it is duty bound under the law. Read the definition of data fiduciary in the act. And you, as a user whose data is gone, is called as data principal. Now, data principal and data fiduciary. Now, the data fiduciary's next liability or next duty or obligation that comes is, we have done consent, we have done access, we have done recall, we have done correction. Then comes the very important aspect, that is right to erasure. That though I have given it, I want to delete my data, I want to exercise my right to erasure. And you can very well ask companies that please delete my data. Now, this deletion has to happen not just at your company's level, but you have shared it with, let's say, 10 third-party vendors. And those 10 third-party vendors have shared it with 40 third-party vendors of theirs. So 10 plus 40 plus 1, which is the main data fiduciary. Everybody has to delete my data. In the absence to do that, the liability will be of that number one company. And let's say one has completed, but the two of those 10 companies which the data has been shared has not completed, still the liability will lie on them, and then they'll have to transfer their liability to showcase, to bring in that transparency and accountability in the world of internet, which was practically invisible, acting as a black box. So this is what your rights are. The next right that comes is right to nominate, which is practically not there in European law of GDPR or other countries, which says that data is an asset. Hence, at the event of incapacity of mind or in the event of death, you can nominate somebody else on your behalf who can utilize that. They can continue, or they can exercise right to erasure or recall or whatever they want to exercise it. And then right to grievance redressal. That means, if something has gone wrong, you have a right to grievance redressal. They are not opaque or not non-existent for you when it comes to complaints. And security is another aspect of it, that they need to, companies, as an obligation, these companies have to have a security in place, a reasonable security in place. With the rules, they have also added the word that masking, obfuscation, or anonymization are the things which they can continue and utilize it when it comes to security aspect as an additional part of it, when it comes to reasonable security standards which each of these companies have to maintain. So this is in a nutshell your DPDP Act. Now, what happens if you don't do this? Let's say you don't take my consent in those 22 languages and you don't tell me what data, what purpose, and how do I exercise my rights. What happens? You're looking at up to 50 crore of a penalty for not giving that option. Let's say you give me that option, and in that option now there is no place where I can exercise my right to erasure, right to correction, right to nominate, right to access. Again, you're looking at for each non-compliance up to 50 crore of a penalty. Let's say you create a facade. There is a place on your website or your mobile app or any physical way of doing it, whatever ways. As simple as you have taken my consent or my data, same way you should be providing me, and it should be as simple of me exercising those rights. Let's say I request you to do that, and you fail to do it. You fail to make changes when it comes to correction. You fail to delete my data at all the places, which is lying emails, PDFs, Excel sheets, third party vendor, 20 departments, uh, everywhere. You fail to exercise my right to erasure. You're looking at up to 50 crore of a penalty for each non-compliance of each of these rights. It's not together, it's not one, but it's for each one of them. Then comes the aspect of children data. There's an added element which is there in the law for people with disability and children. They're saying when it comes to children and people with disability, additional layer is take the verifiable consent from their parents or legal guardian. In the absence of taking that verifiable consent, you're looking at 100 or 150 crore of a penalty. I'm mistaken, one can always check. But it's a hefty penalty. It's not even 50 crores, it's 100 or 150 crore of a penalty up to is what you're looking at. Let's say you can't do, even after the consent, you can't do behavioral monitoring of children. You cannot provide any data which can have a detrimental impact on the upbringing of a child, and so on and so forth. If you continue to do so, or if it's been found that you're doing that, you're looking at again 100, 150 or 200 crore of a penalty. I have to check that, but it is running in between 100 to 200 crores. With this comes the next, that is there any change? Let's say I am a company which is very small. I have hardly a turnover of, let's say, 50 lakh rupees. And a company like Meta or a company like a bank or a large financial institutions will have a different way of doing it. Is there any difference? No. When it comes to quantum of punishment, it has nothing to do with the size and the turnover of the company, but it has to do with the volume and sensitivity of the data and how fast you were in mitigating the risk, how fast were in telling the data principle about all these things. That is the deciding factor when it comes to quantum of punishment that can be imposed upon you. Now, the next that comes is how much time do you have to reply to these requests? They say you can reply, you can decide your own timeline, but it cannot be beyond 90 days. So practically, you have to comply with this within 90 days of the receiving of the request from the data principal. And with significant data fiduciary, there's one differentiation that they have done. It is basic fiduciaries and significant data fiduciaries. Significant data fiduciary, they have not given an exact category, but they say it depends. You can be a significant data fiduciary depending on the volume, high volume, and uh, sensitivity of the data, I suppose. So it depends which all can be considered as a significant. So there are some additional obligations for significant data fiduciaries to follow. That means they will have to have a DPO in place. They will have to have an audit to be done every year. They have to have a DPIA to be done every year, and so on and so forth. Apart from this, there is no change in when it comes to penalty imposition, whether you're a small company or a big company, whether your turnover is very high or turnover is very low. No, it nothing to do with that. I think that's about it when it comes to your DPDP Act. Implementation timeline, November 2025, the rules gave you timeline. Each and every company to comply with the entire compliance has to be done by November 2027. Yeah, so in a nutshell, May 2027 is the deadline that you have with you, 18 months from November 2026. This is your deadline. Any one day after that is where you're looking at these penalties for non-compliance. And when it comes to security breach, there is an up to 250 crore of a penalty when it comes to security. So you're looking at these hefty penalties, not it can be per breach additional to it. And you're looking at hefty penalties, but don't look it in the part of penalties only or reputation loss only, but think of it that you individually is a data principal. Ideally, every company who's taking your data should keep your data secure and should have basic hygiene of asking you what data they're taking of yours, what will they do with the data, how will you exercise your right, can you recall the consent you have given today, or just it becomes a late state of lawlessness. So same way, if you look into it, when you will be implementing it, you will feel much easier and much lighter that you are doing this something which ideally anybody and everybody who's taking that data should have done it and should do it. And I think that's about it when it comes to DPDP Act. If you have any questions, please feel free to ask.
All right. So thank you so much, Ms. Khushbu. This session on the DPDP Act was surely very insightful and practical. We have a couple of questions here. First question that we have is from Mr. Narayan Kumar. How have the Swiss banks ensured privacy and secrecy of its account holders? The data is not shared even with governments.
Okay, I don't know how you're linking that with DPDP Act, or there's a scary part that DPDP Act will bring in that they will share the data with the government. There is no such thing happening with the DPDP Act that government is gonna now have an ownership to the data or access to the data what China has bring in their law. No, we don't have that. When it comes to a bank or any other company, they can have their own robust security policies and safety policies and privacy policies, which we expect every company to have it, and that's what they do it. They keep the data secure and they keep the data private by having an understanding or a contractual understanding between them and their user, and that's how it continues. But it has nothing to do with the DPDP aspect of it. DPDP aspect practically tells you when it comes to exercising your right as a data principal and how what are rights that you have when it comes to implementation of that. But I think your question is linking towards the aspect of government part of it. We can have discussion somewhere else, not when it comes to DPDP part.
All right. So the next question we have is from Mr. Raju. Consent in 22 languages, is it okay in general speaking English and mention as if the data principal intended to choose any other language then that can be provided?
Yeah, can be provided, but without that providing and taking their consent, you cannot continue to use their data. So you can actually do that. You can say that you will provide in English, but let's say I am in Maharashtra and I want to have Marathi, or I am in, Gujarat and I want to give it in Gujarati or whatever the language I want to put it across. If you don't provide me, till the time you don't provide me that, until the time I don't give you the consent, you cannot use my data. So yes, take as much time as possible, but you're losing on a client or a customer or the data that you want to use.
That's great. He also asked, does this works for employee-employer scenarios?
Yes, it does, but employee is also a data principal. But at the same time, you will have a contract in place, and you will have consent in a contractual manner and things like that. So it can have a little different, though it will attract DPDP Act, but at the same time, you will have a different understanding, because when it comes to consent given in a contractual basis and understanding of it, you have a much stronger consent in that manner, and utilization of documents or utilization of personal data in a different manner. But any data, let's understand, any data of any person which you're using, which can personally identify that person, which is in a digital format, is where the act is applicable. Stop thinking it is just the phone number, it is just the phone number and address, it is just the address and this. Any data which can personally identify that, oh, this is Khushbu Jain or this is this, and that data is lying with you of a person, that is where the DPDP Act is applicable on you. Next question.
All right. So the next question that we have is, it's from Mr. Rajasekhar. Does it have a retrospective effect?
No, it doesn't have a retrospective effect, but you do have DPDP Act, which came in 2023. So when it comes to security, yes, you can think of security coming from the year 2023. But when it comes to applicability of the Act, they have given a very clear understanding that from the May 2027 is where it will be applicable. It doesn't have a retrospective impact applicability to it. But when it comes to security, plus you can look into other laws. Like, for example, SDPI was already in existence under the IT Act, which says sensitive information, reasonable security has to be keeping in mind, and others. So till the time this doesn't come, that was in question, but not what we have. DPDP Act, it is May 2027 is your date.
All right. The next question is, what if we don't handle any data of our clients except exchange of emails?
Exchange of emails, mein, what do you have? You have their email address, you will have their basic understanding. Anything, I'm again saying, forget everything, just close your eyes and say, with this, can I identify? Yes, I can identify. My email comes to you tomorrow. It is Khushbu Jain's email. It might have other information in it. So this is Khushbu Jain. No? Are you getting it from X from at gmail.com without any understanding that this belongs to Malik or Khushbu Jain, then absolutely fine. It is anonymized. But anything that can personally identify a person, that is something which is covered.
Next question is from Mr. Nikesh. How to comply? Do we need to add some services like how we are solving the problem? Is there anything that we need to integrate, like we can Google CMP, which is for GDPR?
You can see compliance again. It depends on how large scale your company is and how you are, and whether you want to have technology enabled solutions in your organization, or you can continue with non technology enabled, or you can have a combination. It is practically up to you. But when it comes to compliance, basic understanding is you need to have an understanding of how much data, where it is lying, and how much duplicacy, and in what format they are lying, so that tomorrow when request comes, which all departments or which all places you have to amend or access or delete the data, or whether you can delete or not, because deletion is also not that simple. There are different laws which have a retention norms, so that those retention norms will have to be complied with. Over and above is where your deletion will come in place. So you will have to have that understanding of mapping and discovery, and I think that is where it is required. On top of that, mapping and discovery, if you can create a technology enabled solution that you can understand that this data is, let's say, in 10 departments. If a request of Khushbu Jain comes, those 10 departments should be alarmed. And with that alarmed part is where, once they are done with that ticker that they have done, it will stand as a complete part, and you can implement it. And let's say 10 third-party vendors will also be alarmed into it. So if you can have that technology solutions in your organization, perfectly fine. It's how you want to comply. The solution is the real answer is you have to comply with it. Now, how you comply utilizing technology, absolutely perfect. And keep a record keeping of entire things of this, because without record keeping it would be difficult for you to go to data protection board tomorrow and do it. I think the next question of Kapilji is, will there be an independent tribunal for governance of these disputes? There is a data protection board. There is a budget allocated for data protection board already in the last financial budget by Nirmala Sitharaman ji, and data protection board is a dedicated board for this. It is same as GDPR related. Every country has their own data protection boards, IC or others. India will also have it, which will look into it. It can go suo moto, or you can complain to the board. Once you complain, it will continue. Any penalty that is imposed will go to Consolidated Fund of India. If you, as a data principal or as a complainant, do a frivolous complaint, there is a 10,000 penalty that can be imposed on you for those frivolous complaints. Next.
All right. Mr. Raman asks how to ensure that if this act applies to my organization, is there any ready reckoner or checklist?
Whether applicability part? Yeah, applicability part, as I said, if you're dealing with two elements also, which can personally identify in a digital form, whether you're collecting in a physical form but converting into a digital. A lot of times even those forms can be clicked via WhatsApp and shared via emails or whatever. The act is applicable on you. There is no rule book to understand. It's a very basic data of anybody which can identify them personally. You're keeping that or utilizing it in a digital format, whether you are a medical shop, or whether you are a mom and pop shop meme page, or whether you're whatever. You are taking data of people which can identify them. The act is applicable on you.
Oh,
And what you should do, you should either start working towards it. It's a basic act, pick up the act. I told you the liabilities. The rights of each and every individual is what it can be converted into an obligation. You have to start complying with those obligations. You can take help from organizations who are helping out in compliance. My firm is also helping out in compliance, but there are a lot of firms which are helping out in compliance. You can always reach out to those firms to make you understand that how big your organization is, and the volume of data that you deal with, and then what is the plan that can be orchestrated for you. It can be a 6 month or a year old plan, depending on the size of the company and the volume of data. And that's where, and the privacy posture that you have right now, internal posture in your organization, depending on all that, the timeline can be decided, and they start implementing it for you. And they can create a rule book for your internal privacy structure forever, so that your organization knows how to continue with the same process.
all right. We have another question. How will it have an impact on the organizations who will have to take aspirant details for processing the offer to make them join and work with them? Do we need to add this in the appointment as a clause?
Yes, you need to ask them their consent very clearly, and you have to tell them that how do they exercise their right. They can always continue after maybe they have done the job, that they can request their right to erasure, or they can continue in between that I don't want to continue with your services, and they can still exercise their right to erasure, or they can recall their consent and whatever. But you have to take their permission. It can be a small consent, but you will have to provide them with a proper consent of privacy consent notice, which will tell them the details and also tell them how to exercise their rights. Very important. Without that, should not do it.
All right. The next question is from Mr. Sachin. In this act, any technical configuration guideline is defined for data security?
Security, they have got it very clearly. They are not talking about anything. They are saying that you as an industry should understand what are the reasonable security standards and procedures for you, and comply with that. It can be ISO 27001 and 277 whatever, or you can, sorry, 27001, or it can be anything. It can be NIST guidelines. It can be HIPAA if you're in medical. You pick it up, pick and choose. Don't want to do anything, just put nothing. But if you're breached, is where they will see whether you have complied with reasonable security standards or not. And that's where quantum of punishment, when it comes to that, up to 250 crore will be implemented on you. So practically, they are not forcing you to do anything, but in the event of breach is where you will have to see through. So best is to have industry specific, at least the basic reasonable security standards. You start complying and implementing it, and then keep on upgrading yourself from that part. So apart from this, the rules have specifically spoken aspects of obfuscation, data masking, and I think pseudonymization. Look into it, and there's just basic 3 4 terminologies that they have put it in the rules.
All right. So the next question is when a user withdraw his consent, what are the data that could legally be retained and why?
Okay, this is a very lengthy question of yours. Depends on the industry that you're into. Like, for example, IRDI or telco. So if we pick up telco has its own guideline where under the act, the TRI says 2 years tak the data has to be retained. CDR and IPDR data has to be retained by them. Aadhaar is applicable on them. Aadhaar says certain data has to be maintained for next 2 years, certain has to be maintained for 5 years. PMLA says Prevention of Money Laundering Act that this data has to be retained for 5 years or 7 years. Income Tax Act has its own policy when it comes to retention. So depending on the type of data element, And depending on which act is applicable on you is where you create your own retention module, and that retention module will be the one which will be the guiding force when it comes to request for data erasure. So let's say today I request that I am no more an Airtel customer, I have switched to Vodafone, I want to exercise my right to erasure, and I want to exercise my right to recall and everything else. But though valid that I'm no more your customer, delete my KYC, delete my everything, delete my IPDR, CDR, delete everything. I'm no more your customer, I've shifted. But by law, they cannot do that. The data which is there, 2 years that they have to maintain it. Certain data they have to maintain it. So they will maintain that. But let's say advertisement, marketing, or 20 other data which has no legal requirement under any other act, they will delete right now. But let's say Aadhaar or IPDR or CDR, they will delete it after 2 years of expiry of it. So it practically goes in that part. It's a very tedious job. It can't be answered like that to you. But yeah, you will have to create an entire matrix when it comes to data retention so that erasure can be complied with.
All right. So the next question is, how about using pseudonymization techniques while using an AI tool for legal matters? Is that compliance with DPDP Act?
Anything that can personally identify a person is something, and you're not taking any consent or you're not doing it, don't do it. Anywhere where you can continue with the technology, it can have an aspect that it can't de-anonymize or it can't go, it can't connect with the person again. Continue. You cannot continue without a consent. So best is to take a consent. If you don't take a consent, then put it in a manner that it doesn't relate to the person. It anonymize or pseudonymize in a manner that it has nothing to do with the person relatively. And if you can't do that, then don't do it without consent, please.
All right. The next question is, given that majority of children being online, how will the verifiable parental consent work in practice?
This is a very good question. So the law is very nice. Law is saying you are a data fiduciary, you want children data, you figure out a way to how to verify the consent. If you're not able to do it, I will punish you. This is something like there is a bar, the liquor is served, 21 and above is the age limit. Now let's say a children is found in that. The punishment is on that owner to bring in somebody who is not at the age which is 21 and above. So you stand outside, you see their identity cards, you put in two people without the entry point, that is up to them. But the liability is of those guys, not of the guy who is inside, who is, let's say, 20 or 18 years old. Same way when it comes to theaters, you have when it comes to movies which are underage, which can't be watched by the underage. Again, if you don't put people and they're found, it is the punishment of liability on the those. Same way they're putting on the digital form that you want to take children data, you want to take their you want them as a customer, take a verifiable consent. How you do that, up to you. But the best would be there are a lot of mechanisms where you can do it. How you do it is something I think each and every company has to look into it. I do have an account to it, but yeah, that is depending on what kind of industry that you're into, and we can help you out in that. That's like not doable.
All right. So the next question is, what does the DPDP Act and rules mean for education institutions as they receive data from thousands of applicants for admissions?
Complies on you also. Everywhere it complies. I mean, it doesn't change that, oh, you're an educational institution, don't deal with it. No, no, it is applicable, but there are certain carve-outs in the act when it comes to things. Those carve-outs you have to look into, but that is also very restricted to those specific thing. Everything else it complies with. So behavioral monitoring, for example, is something which is not permissible, but at the same time, this is when it comes to security. So only with that aspect is where the carve-out is there, that they don't have to take consent, and if they deny, they cannot do that. But rest all other things, the act is applicable, or those obligations are applicable on them.
All right. So I think this is the last question for now. It says, how does the data principal redress his or her grievance by a suit or a complaint or any other mode?
Okay, the whole aspect was not to give you into the suit issue where it becomes a problem, is where you complain to the data protection board, and once you complain to the fiduciary itself as your grievance redressal, and that's where the next question will go, that once you're not happy, you go to a data protection board and complain over there, and that's where your complaint will continue. Wait for some more time. 12 months has been what has been granted for the data protection board to be enacted and out and running, which will have a lot of terms and conditions and process defined when it comes to how do you complain, what format and how it has to, and that's where you'll get the clarity. But the whole idea is to make process much more simpler as compared to what you have it when it comes to filing of a suit, hiring of a lawyer, and going on, in that entire process.
All right. So it's been a fantastic discussion on navigating DPDP and AI compliance 2026 and beyond. A heartfelt thank you to our speaker, Ms. Khushbu Jain, for sharing such insightful, for making this session very insightful, and to all our attendees for joining in and making this session truly engaging. We can see that by the number of questions that we weren't able to take in. And with that, thank you once again, everyone, for joining us today. This is Malika Arya signing off on behalf of India IT 360 and Techie Connect. We hope to see you again very soon in our upcoming webinars. Have a great day ahead.